Welcome folks to today's Power Hour. We will be covering the EU Machinery Regulation. I'm going to share the main aspects of that with you this afternoon. Yeah, look forward to that. For those, I think most are familiar with me, but I'm Dale Camsell. I'm the Senior Technical Consultant to the CEA. My email address is shown here on at the bottom of this slide. The slides will be shown. I'll come on to that in a moment. The slides will be shared afterwards. But please, if you do have any questions that aren't answered today, please don't hesitate to get back to me at after this event with your questions. So, as usual, we'll start with the internal procedures. So this webinar is held in accordance with the CEA Corporate Compliance Policy. That is available on the CEA website, and I've left a link there in case you have any queries on that. The webinar is being recorded, and it will be made available along with the slides that I'm going to be showing on the CEA website. I'd ask you to stay muted unless you're going to ask a question, and I would normally prefer these sessions or any online session to be interactive and questions to pop up at the end of each slide. But because of the amount of material we've got to get through today, and to try and ensure that we get through all the material, I would ask that you pop your questions into the chat function, and I will then review them afterwards. This also ensures that any questions that I'm not able to answer in the time that we have allocated, which is till 2 o'clock, I can answer afterwards. So if you pop any questions into the chat as we go along, as I say, I'll try and answer them at the end. But if not, I will answer them after the meeting is finished, because all the questions are saved in the chat. Okay, sorry, it keeps bouncing back to the beginning. So, yeah, today's topic then, the revision to the Machinery Directive, in other words, the creation of the new EU Machinery Regulation. So, yeah, the directive is the fundamental piece of legislation that is in place at the moment for putting machinery into the EU market. It sets out all the major requirements for all aspects of machine safety, and I've identified some, not all of the major aspects of the directive there, and it's been in place for some time. It was first published in 2006, but it's been in force since 2009, so some number of years, and due to that time lapse, the European Commission felt that there was a need to update it, mainly to take into account the rise in new technologies, those new technologies being artificial intelligence, autonomy, cyber threats, as well as other advancements in digital technology. So there was a need seen by the European Commission. Not all stakeholders felt that it necessarily needed to be updated, and they felt the existing provisions adequately dealt with these aspects, but the European Commission and probably most member states felt the need. So the revision process has been underway for some considerable time, actually. Seen more rapid progress in recent times, and we are just about on the threshold of it being published. I'll come on to the status in a moment. Just want to highlight, though, before we go into the technical aspects, just to advise and remind that although the UK has now long left, I guess, the European Union, the CEA is still a main player in CC, CC being the Brussels-facing Pan-European Trade Association, of which CEA is a member. Our membership was not affected by Brexit, and we still play a very active and contributory role to CC activity. In fact, Jason Ong, of the CEA, he works for Komatsu, chairs the project team in CC that deals with machinery. So we remain a highly influential force within CC. Just wanted to reassure folks that we still have that influence in CC despite recent political changes. So coming back to the Machinery Directive itself, This plots out the procedural aspects of the progress of the revision. So back in April 21, the European Commission published its original proposal for the regulation, since when the European Council and the European Parliament have in parallel been developing their proposed amendments to the original European Commission proposal. Then for the last months of last year, the three parties were locked in negotiations, as called trialogue negotiations, as they're called, to come up with compromises, to come to agreements on all of the different positions, and then to adopt a final text that they were all happy with. That has happened in quite recent times. Actually, the formalities have been completed, and we now have all three institutions have signed up and voted to the new text of the regulation. The only outstanding items to go through are the legal linguistic checks, just to make sure that the regulation is fit for purpose and translates well. But in terms of all the technical aspects, that is all now complete. We haven't quite seen the publication of the regulation yet. But we are expecting to see it in early July, so very shortly should see the citation in the official journal of the European Union. Sorry to use jargon, but this is the correct terminology, which basically means publication of the fixed and final text of the regulation. It will then enter into force 20 days later, so we would expect that to happen in late July. That's not really any thing of consequence initially, at least for manufacturers in terms of compliance with machines. There then follows a 42-month transition period before the application date of the machinery regulation, and that means it will be applied from sometime around January 2027 if these dates are held. On the same day as the machinery regulation is applied, the existing machinery directive will be repealed. So we'll have a switch over at midnight from one regulatory regime to the other. That I'll come on to the challenges that will cause us in a moment, but just to say that the legal text will not formally become available until this happens here, until July 2023. So a few weeks away yet. However, the European Council is obliged to publish the documents that it is voting on, and since it has formally voted to approve the text, and the European Parliament had already voted to approve the text, then the final, what is likely to be the very final version of the text is available. That has been uploaded to the CEA's technical library. If you click on that link when you receive this document, you will be able to see it. The only changes that might happen between now and the publication, as I say, are following any legal linguistic changes, but that will be more grammatical changes, not changes to the substance of the text. Oh, sorry, this keeps doing this. All right. However, there is one very important aspect to point out, and that is the fact that no voluntary early application of the MR will be allowed. So up until the machinery directive is repealed and the machinery regulation is applied, which, as I say, will be a coincident, products must comply with the machinery directive up until that point. Thereafter, they must comply with the machinery regulation. So I've just put a little table here, which hopefully will help to describe that. So if a machine is compliant with the machinery directive, it can be placed on the market now, prior to entry into force of the machinery regulation. This is where we are today. Once that regulation enters into force, which expected July this year, the machinery directive will still prevail, and products must comply with the machinery directive in order to be sold into the European market. However, once that critical date, expected to be in January 2027, occurs, then the machinery, then products sold into the European single market must comply with the machinery regulation rather than the machinery directive. So this is the timeline here. This causes us some challenges in terms of how to deal with the declaration of conformity. This is the document that goes with the machine and declares on behalf of the manufacturer that the machine complies with all relevant legislation, because of course on one day in January it will only be able to comply with the machinery directive in order to be placed on the EU market, but the day after it can only comply with the machinery regulation in order to be placed on that same market. And of course the declaration of conformity is produced at the time the machine is generally is produced. Therefore there is it gives a bit of a headache in terms of what do you put on the declaration when you don't know exactly when the machine might be placed on the market. One possible solution has been proposed by industry, and that is you could, provided of course the machine complies with both the machinery regulation and the machinery directive, and it's likely, highly likely, in fact almost definitely the case, that if a machine complies with the machinery regulation, it will comply backwardly with the machinery directive. So if you comply with the regulation, you're undoubtedly compliant with the directive, and therefore it will be quite safe to put that you do comply with both sets of legislation on the declaration of conformity, and this of course could be implemented some period before this switchover date, so that machines that are entering the market and around about that period will be covered in both scenarios. This might not be the situation. Your machines might be placed on the market as soon as they're manufactured, so it depends on your circumstances, but in any case there is a possible solution here, and I say possible because this is being proposed by industry. The European Commission is looking into whether or not they can agree to this. They're seeking legal advice, but they will come back to us later in the year to declare whether or not this is an acceptable solution. So let's jump back again. A bit of a spoiler here. Digital instructions will be allowed. I'll come on to this later when I go into some of the technical details. So yeah, just jumping ahead slightly. Digital instructions are allowed, explicitly allowed in the new regulation, and we were hoping that they would be able to be implemented as soon as the entry into force of the new regulation is upon us. However, because of this situation where at the moment the existing guide to the machinery directive states that paper instructions, so this, when I say instructions, I mean operator's manual. Different companies call them different things, but in legal terms it's the instructions. So the operator's manual is expected to be provided in paper at the moment because of the wording in the non-legally binding but a highly regarded guide to the machinery directive. So what the solution proposed by industry again here is that if the guide is revised to take out this expectation that paper instructions are to be delivered along with machinery, then that means that we could effectively implement the start of digital instructions before the application date of the regulation, because there isn't actually any contradiction between the two regulations. The existing directive does not say anything about the form of the instructions, it just says instructions have to be provided, whereas the new regulation says that digital instructions are allowed. It doesn't say they have to be digital. They can be paper or digital. That's up to the manufacturer. But it simply says that digital instructions are permitted. So therefore, there is no conflict. There's no contradiction in the regulations. So if we do get the go-ahead from the European Commission and the guide is changed, the guide to the directive, of course, that is changed, then it could be that we could implement prior to the application date of the regulation digital instructions. So we're still looking into this. Obviously, I'll keep members advised as the situation develops. But most manufacturers are very much welcoming of the opportunity to provide digital instructions, and and might well implement them at their first opportunity. Okay, so legal context. Personal opinion to start with. Okay, this is really important, this overview here, and certainly the first couple of lines is more of a personal opinion, and that is that the final requirements in the regulation seem to be, on the whole, reasonable. Many machine types won't be affected by the changes if you haven't incorporated any of the new technologies that I mentioned earlier, or any of the other changes that aren't relative to those new technology changes, which I'll come on to shortly. Then you might well find that there is no change whatsoever to your machinery, and you can continue to place machines on the market without change, other than obviously any documentation changes, etc., that are needed. When the European Commission first published their proposal back in April 2021, many of the inclusions there were highly problematic and would have caused severe headaches to us. But through successful advocacy, and as I say, CEA was core to that initiative, we have a final set of requirements that are broadly much more acceptable. However, there are still some significant challenges to overcome, which I'll come on to in a moment. I've already mentioned the word regulation frequently. Just to confirm that this the new legislation will be published as a regulation, so it will take over from the directive. In terms of technical requirements, that makes no difference, but it does bring a big improvement in terms of the consistency of application of the legislation, because a regulation has to be applied on the same day right across all member states, and they have much less opportunity to modify aspects of its application, at least. So industry welcomes that it's a regulation rather than a directive. And the other thing to note in terms of the legal context is initially the machinery regulation proposal, as I mentioned, which came out back in April 2021, was published at the same time as the artificial intelligence regulation, because the two of them went hand in hand. In fact, the machinery regulation made direct references to the artificial intelligence regulation. However, due to hold-ups in the development of the artificial intelligence regulation, and for other reasons, the two have been decoupled, and each will be separately and independently published. So just one change to make you aware of there. So going actually into the detail of the content. So the structure of the regulation follows the usual pattern, in that the first chunk of text are all the recitals. These are non-legally binding. It's basically some background and justification as to why the changes have been made, but there's no legal consequence directly of those. We then have the articles. These are legally binding. These are more about the regulatory framework, how it fits in, how it is implemented, what the obligations of economic operators, member states, etc. are. So this is, as I say, all to do with the application. They are very important to us, but they don't contain the technical element. The technical elements are all contained in the annexes, which is the third chunk of text in the regulation. So not going to cover the recitals, because, as I say, they're non-legally binding. I'm going to jump into the articles and go through these. Not all of them. There's 50-something of them, but just the ones which have a significant consequence and that I need to draw your attention to. So, and there'll be a bit of flipping backwards and forwards here as well, because the articles link to the annexes and refer to the annexes. So there will be a bit of toing and froing. So please bear with me on that. So Article 5 provides empowerment to the European Commission to modify Annex 1 through delegated acts. Now, Annex 1 lists the machinery types that require special conformity assessment procedures. Annex 1 in the regulation is equivalent to the Annex 4 in the directive. So it's where you might need to involve a notified body when performing a conformity assessment. Now, this is probably a good thing that the European Commission has this empowerment to modify that list, because at the moment in the Machinery Directive we have a list, I think, of 23 or so types of machinery, but they were fixed. They could never be modified. So some of those should have been withdrawn years ago, but there was no mechanism to do that. And perhaps it could be argued that other machine types should have been added, but that would have required a full revision and would be very time-consuming and resource-demanding. So it hasn't happened. So the European Commission has this empowerment through delegated acts to modify the list of machinery that require special conformity assessment procedures after the publication of the regulation. So this is relatively, I think we're relatively comfortable with this, provided that it's done in a controlled and time-sensitive manner. I'll come on to the Annex 1 content of machines in a moment. Partly completed machinery is dealt with in a more head-on manner, shall I say. Previously, there were still a lot of questions and interpretation about PCM. In certain aspects, the way that PCM is dealt with in the regulation is improved. However, one concern from industry is that the requirement is that PCM must meet all relevant essential health and safety requirements. So this is all the technical requirements that are listed in the regulation. Whereas the current situation is that it is down to the manufacturer to decide, the PCM manufacturer that is, to decide which essential health and safety requirements the PCM complies with, and to declare those in the declaration of incorporation that goes along with PCM. But there is no requirement for them to meet all essential health and safety requirements. In fact, we argue that it's impossible for the PCM manufacturer to know which are the applicable relevant health and safety requirements, because they don't know where the PCM might end up. But anyway, this is to be sorted out at a later date, maybe in the guidance, and we'll come on to that. And maybe the fact that it says relevant essential health and safety requirements is the way, the means by which we can ensure that the manufacturer is not caught out. The PCM manufacturer is not caught out by this new requirement. Die. Sorry about this, it keeps jumping back. I'll pass that. Okay, so I already mentioned about digital documentation and that the digital instructions are explicitly allowed, which is great news. As I say, they are not mandated. If you wish to continue to produce paper instructions, then that is your prerogative. You can, though, if you wish, produce digital instructions, and of course, they offer many benefits to many stakeholders. If you do provide digital instructions, then the information as to how to access them must be marked on the machine. So you could have a QR code, or you could simply have an email address as a sticker in a visible area on the machine, by which you could scan the QR code or enter the URL into the internet search and find the instructions. So you must provide obviously how to find the instructions, and they must be downloadable. And also and this includes in the situation where the instructions are embedded, which is more often the case in automotive, in cars these days. But if you do wish to put the instructions embedded in the interface, in the interface with the operator, again, it must be downloaded. The instructions must be downloadable. They must remain available downloadable for 10 years after the product is placed on the market. So machines in service, they can still have the instructions downloaded by users if need be. And importantly, although the manufacturer has the discretion as to whether or not to produce paper or digital instructions, if they do provide digital instructions, it is still it is still there is still the opportunity for users to request paper instructions. They must do so at the time of purchase, and the manufacturer must do so free of charge. I think they have 1 month or 3 months to provide them. There's some curiosities in this, the wording of this text. I think when they talk about users, so they're probably thinking more of the commercial market for retail products rather than professional products, because obviously the users of professional products don't necessarily do the purchase themselves. It would normally be somebody, some other party. But anyway, this clause remains that if the user requests at the time of purchase a paper copy of the instructions, then they must be provided free of charge within a certain time period. Now, this probably doesn't affect the vast majority of CEA products, but if the product is intended for non-professional use, or even if it's not intended but it's foreseeable that a professional product could be used by non-professional users, then the product must be accompanied by a paper-based tag, if you like, which contains the essential health and safety information. So this is not the full instructions; it's the information that is deemed to be essential for the safe use of the product. This is not defined. It isn't. We don't know what this means, but it does. This will require some further work. This may or may not affect the people on this call today. So we'll see what transpires. I keep doing that. Sorry, I've got to use the mouse. So Article 17 covers common specifications. This is the first time we've seen this in our in the machinery or any pieces of other legislation that directly affect us, I believe. Common specifications are the effectively the equivalent of a harmonized standard that the European Commission is empowered to produce if the European standard development agencies such as CEN or CENELEC fail to, for a number of stated reasons, produce a harmonized standard. They will hold the same status as our harmonized standard and importantly provide a presumption of conformity. But the European Commission holds this power. They have said they will only produce common specifications as a very last resort. They fully recognize and understand the value of harmonized standards developed through a consensus-based approach, but they do retain this right. Our only curiosity is what the process will be, who the stakeholders will be. These will be non-consensus, we believe, so the European Commission still, we believe, will have the ultimate right to decide the content. So we do have certain concerns, although stakeholder involvement is mandated in the legal text. So we will, at least as industry, have be able to input to the development of any common specifications if they're required. Hopefully, these will never be needed, and harmonized standards will always be produced to cover the needs. The Article 21, right? This is one of the major areas that we had concerns with when the first proposal came out. So Article 21 lays down the conformity assessment procedures of those machines types that are listed in Annex 1, i.e. those that require special conformity assessment procedures, which could involve the could require the involvement of third-party conformity assessments. And what the original proposal from the Commission did was to take everything that's in the existing Annex 4 and put it into Annex 1 and add a couple of other aspects, machine types. Yeah, we were pretty unhappy with that because we felt there was no justification to take every machine type that is currently listed in Annex 4 and put it in Annex 1, because we felt some of those should have been removed long ago and there was no real justification for continuing that need. Again, I'm pleased to say that we had great success in this aspect, and it was quite a tough battle because there were many stakeholders that were against this change. And Annex 1 has now been split into two parts. There is a Part A, which will require third-party conformity assessment, regardless of whether or not harmonised standards exist. And there is a Part B, which is now the equivalent in terms of conformity assessment procedures as the existing Annex 4 of the directive. And that is lists the machinery types where manufacturers can self-assess, provided that harmonised standards are available that cover all the essential health and safety requirements. So just to actually put some colour into this, I've jumped ahead to Annex 1, and these are the 6 remaining of the original 25 items, the 6 that are remaining. And I think only items 5 and 6 will be of interest to this stakeholder group. And what they cover are safety components that are either placed on the market separately or are embedded in machines and the machine placed on the market, and where that safety component is A, fully or partially behaving, partially self-evolving behavior using machine learning approaches, and B, ensures a safety function. So, bit of a mouthful, just to go through that and break that down a bit. So, this safety component, where it contains, and it doesn't say AI, it says fully or partially self-evolving behavior using machine learning approaches. That used to say artificial intelligence, and it used to refer to the AI regulation. Because this link has now been broken between the two pieces of legislation, then this is why this new text is in here. So it's code for AI. It doesn't say AI, but if you have fully or partially self-evolving behavior of safety components that importantly ensure safety functions, not operational functional means just safety functions, then they will fall within Part A of Annex 1. And the big question then is, well, if they do, so what? How do we comply with that? The way to comply with it would be to actually comply with the AI regulation. So the AI regulation contains text, which effectively means that if you fall within the scope of those items 5 and 6 on the previous page, then by complying with the artificial intelligence regulation, you will comply with those items. So that link, as I say, is not direct, but it is indirect now and remains between the AI regulation and the machinery regulation. But this is how you would comply with these items 5 and 6 here. It would be through applying the artificial intelligence regulation. That in itself is another chunk of legislation which we don't have time to go through today, and I would plan to include that in a future Power Hour for you. Excuse me. So just for completeness, we also have Part B of Annex 1. This has 19 items in it, but I don't think the first 17 are of particular interest to this group, so I haven't listed them, but items 18 and 19 undoubtedly are, but these are in Part B, so provided there are harmonised standards, which there are, then manufacturers can continue to self-assess if they so wish. Of course, they can involve a notified body if they want, but they can self-assess if they wish. As I say, originally, that self-assessment right was taken away in the original proposal, but through advocacy, we managed to bring that back, which is good news. Then we come on to the Annex 3, and there are two closely linked essential health and safety requirements. 1.1.9, which is protection against corruption, and quite a few words here, but basically the machine hardware that transmits signals or data must be adequately protected against accidental or intentional corruption. And software and data that is critical for the compliance must also be adequately protected against accidental or intentional corruption. And the same for in section 121, which covers control systems. specifically the safety and reliability of control systems, and these must be adequately protected. Again, the same words, adequately protected against accidental or intentional corruption. The question again is, well, how do we do that? How do we adequately protect, and what is adequate protection? Well, for both of these clauses, the way to comply, the preferred, well, the suggested way to comply would be through the Cyber Resilience Act. This is another piece of legislation, and I think you can see here there's a network of legislation that all interlinks: the machinery regulation, the Cyber Resilience Act, actually the Radio Equipment Directive, which I'm not covering today, and the new machinery regulation are all very, very intertwined in terms of how you get compliance. But with regards to 119 and 121 of the machinery regulation, there is this new Cyber Resilience Act, which is being developed, and there is actually an article in black and white in the Cyber Resilience Act that has words to the effect that if you comply with the Cyber Resilience Act, then you will be deemed to have complied with the cyber aspects of the machinery regulation. So that would be the route to compliance. It is also under development and is expected to be published in around about this time or the middle of next year. Harmonised standards will also be produced. There is a real challenge here in getting those standards ready in time, but harmonised standards will be produced in order to provide a route to compliance with the CRA, and therefore a route to compliance with the cyber aspects of the machinery regulation. So that is a rather long-winded and complex route to compliance, but that is how it should be done. The next big challenge in Annex 3 are related to, or is related to, vibrations. So there are two clauses which are pretty much identical at 2211 and 3631, and that is that in the instructions there must be vibration information that shows the peak amplitude from repeated shock vibrations. Well, we already have some standards covering vibrations, but we don't have any standards for repeated shock vibrations. By the way, this is just the vibrations to which the hand-arm system is subject. It's not whole body, but nevertheless, there are no standards covering this. But again, I'm pleased to report that standards are in the process of being developed. I've included it at the bottom of the page there. I'm sorry, this is jargonistic, but this shows the standardization committees that are in the process of developing the requirements by which you would comply with these two aspects in the new regulation. So because this starts with a 2, this means it covers handheld and hand-guided equipment. So that could be pedestrian rollers or any other pedestrian type equipment that people produce, where the hand is directly on the machine. Wouldn't include remote control machines, and 3631 is for mobile machinery, so where the operator is probably sat or maybe stood on the machine and it's in a mobile form. So those items initially caused raised eyebrows, but provided that this joint committee work between ISO and SEN committees is completed on time, then again we should have a route to compliance with these requirements. Seating, this is a one which is still causing us a headache at the moment. So where there is a risk, a significant roll or tip over risk, and its restraint system is not used, it shall not be possible for the machinery to move. So machines, and there are many in our sector that are susceptible to roll or tip over during operation, have a ROPS or TOPS protective structure. If you have a ROPS or TOPS, you are also then required to have a restraint system, typically a safety belt. Then the new requirements is that if that restraint system is not engaged, if it's not being used, then it shall not be possible for the machine to move. This, of course, is a very stringent requirement. I mean, there's nothing in automotive to require that a car cannot move until your seatbelt is done. Yes, you might get an annoying beeping sound if you drive without the seatbelt engaged, but it is possible to move. Whereas, and of course, cars move at high speed in very congested areas. So it does seem maybe disproportionate. However, despite our best efforts, this clause remained and is still in the final text. So we're stuck with it. So we're now finding ways to deal with it. Of course, we're not sure what move means. Does that travel? Is it when it's only traveling? Because of course, an excavator can be not traveling, but its upper structure could be moving. It could be rotating. The boom and arm could be moving outwards and inwards. Do they mean that sort of movement, or do they just mean traveling relative to the ground? We need to further investigate, interpret this. Of course, it's not only CEA type products that are affected by this. Any other sector where it has machines where roll or tip over is a risk is affected by this as well. So we are working with other sectors in order to get a common understanding, a common interpretation, and then the principles upon which we will develop a standard which would provide a presumption of conformity for this clause. But yeah, this is one of the major headaches we've got at the moment, is how to comply with this one. Then another, we have supervisory control function. So this is related only to autonomous mobile machines. So if you have an autonomous machine, it must have the ability to allow the supervisor to remotely receive information from the machine and some degree of control over the machine. This might be more limited immediately, but of course, as time progresses and autonomous machinery becomes more widely available, it will become increasingly important. Again, there is no harmonized standard covering a supervisory control function. The standardization community is looking into this. Again, it's not just CEA that is affected by this. It is any sector that could have autonomous mobile machinery. So CEA members are working with other sectors, other affected parties, to again come up with a common understanding and interpretation, and then from that develop the harmonized standard that would provide a presumption of conformity with this requirement. Another major issue is the risk of risk of contact with live overhead power line. So this is actually, it was the UK before we left the European Union were the instigators of this requirement, following a number of fatal incidents, more agricultural based than construction site based. But nevertheless, this is not limited to agricultural machinery. It's any machinery, depending on its height, and that might come into contact with live overhead power lines. Then we, as manufacturers, have to provide means so as to prevent the risk of contact with that line, or to be able to ensure that the operator is protected. We have a number of problems and challenges in interpreting this requirement and how to apply it in a way that meets the objectives, the intention of the European Commission and the other two sets of legislators. So again, we're working on this. We're at relatively early stage, but this is a real head scratcher, this one. It's fraught with problems, but the text is fixed, the text is final, so we will have to work with other parties in order to find a means that we can comply with this. So I mentioned harmonised standards a couple of times. One of the very good things that the European Commission have done in the development of the regulation, although there's nothing in the regulation at the moment to say this, they are intending to provide a further annex to the regulation, and in that they will give legal clearance for existing harmonized standards that therefore provide a presumption of conformity with the existing directive, that in the case where the regulation does not change the essential health and safety requirements that are covered by that standard, that the standard can continue to provide a presumption of conformity with the new regulation without any modifications to it. As a minimum, we had previously expected that even if there were no changes to the essential health and safety requirements that the standard covers, nevertheless, the references to the regulation will have to change because the numbering sequences all changed, the annex numbers of an order have all changed. So we would expect, if nothing else, to have to undertake editorial changes, as well as all the technical changes that some of which I've just covered. Well, in the case where only editorial changes are required to update the references, then the European Commission has given we're expecting the European Commission to give us some form of allowance that would provide the existing harmonised standards to continue their presumption of conformity with the regulation. We don't know exactly how that will work at the moment. We're working closely with the European standardisation bodies and with the European Commission to find a workable solution. We're obviously very, very welcoming of this because it means we can do all the editorial work later and we can just focus our attention right now on those tricky technical challenges that we have in updating the technical aspects of some of the standards, and we can then deal with these later. So we're very welcoming of this, but we're not sure exactly how it would work, but we are doing our best to find a way to make them work. So guidance, I mentioned interpretation is going to be tricky on some of these items, and that certainly is the case. And so we all feel that an update to the existing guide. The guide is a document that is produced by the European Commission. And it provides an interpretation of what the intention of the essential health and safety requirements and the articles in any piece of legislation. And we felt, because of all the changes, that guidance was essential. Not just us, but also a number of member states felt that this was a given, that the guidance would be updated. The European Commission didn't see things the right way, and with the best of intentions, their plan was that the text in the legal text in the regulation would be so clear that guidance would not be necessary. They felt that guidance was a means of flagging failure on their behalf of providing clear regulatory clarity, but this obviously is not the case because they've been inundated with questions on clarifying and providing legal certainty on the text of the regulation. So they've changed their tune, which we welcome. They haven't committed to a timeline. In fact, they haven't really committed much in the way of resource, but they certainly have now said they fully understand why we are asking for guidance. Because of the slowness of the Commission to start the editing process, industry has stepped up, and we are already in the process, albeit early stages, of drafting the amendments to the existing guidance document in order to bring it in line with the new regulation. That's at the very early stages. It's work in progress, but we are doing that to give a kickstart to the process. And then, of course, we will share that with the European Commission and other stakeholders so that the guidance can eventually be published in a timely manner ahead of the application date of the regulation, so everybody has a common understanding of the requirements. Okay, so that covers all of the topics I had. I will go into the chat box in a second to look at the questions that have been submitted. However, I cannot leave without bringing your attention to Plantworks, which happens very shortly, less than a month's time. 13th, 14th and 15th of June takes place at the East of England Arena and Showground, which is just outside Peterborough. Attendance is free. Registration though is required, and I've popped a link here as to how you can register. I hope you will all be attending. It's a great show, great experience. Good to have a look at all the machinery, all the products that are there. Great networking opportunity as well. So hope to see you there. If you are able to attend, that's great, and please click this registration link here if you haven't already done so in order to register. As I say, it's free, but you will have to register so that you can get into the site on the day. So that ends the presentation for now. But let me open the chat box, come to the top, and let me see what the first question is. So from Cash, is the machinery regulation to be amended to be in line with the new machinery directive? Well, the machinery regulation will replace the machinery directive. So it takes the existing machinery directive and modifies it, and I've just highlighted in the presentation there what the major changes are in the regulation. There are other changes as well, of course, but I think those are the major ones. I'm not sure if I've misunderstood your question there, Cash, but as I say, the directive will be replaced by the regulation. So there is no intention as such to align it because one replaces the other. There we are. One replaces the other. Ian, my words exactly. I promise I hadn't seen that. So hopefully, okay. So I'm catching up. Sorry, but the MD is being revised. So when will the MR be revised? No, there is no MR at the moment. The MD exists at the moment. It is being replaced by the MR. So Ian, when will the move? When will the move part 322 be resolved as an estimate? 322, which one was that, Ian? That was 322 was the seating. Okay, so Ian, I can't answer that. I mean, as soon as possible. The SEN working group that is looking to develop a solution for this is working with other stakeholders. I know that the ATV community are the ones who are shouting loudest about this, but of course there's all sorts of other stakeholder groups that are affected by this. So there is no certainty at the moment, and I thank you, Alessandro. It looks like yeah, perfect, Alessandro. I endorse what Alessandro said there. Oh, Ian, you didn't hear my response. Okay, maybe I'll answer that separately. Gail, hi Gail, and apologies again for not responding to your question on noise. I will come to that separately outside of this meeting. Great question, and I'd meant to include this in my presentation, and that completely slipped my mind. Will the UK regulation change to be in line with the machinery regulation? That is the question on everybody's lips, of course. That's a huge question, and I can confirm that I have asked this repeatedly of the UK authority. It's of course of huge importance. We also have the Outdoor Noise Directive, which is in the process of being changed. So just to take a step back, all of these safety regulations, so obviously the noise legislation, the the machinery regulation, EMC, low voltage directive, stage 5 regulation, all of these regulations were basically copied and pasted into UK law and are applied as UK law now. But they were without any technical changes. We are now, of course, in the process, as time goes by, seeing technical changes to the EU regulations, and the machinery regulation and the Outdoor Noise Directive are perhaps going to be the first tests to see how the UK will react. Now, I've asked this a number of times, Gail, and have not received an answer of substance from the UK. Of course, as well as the technical justification for changing regulations, which may be on safety grounds, might be on environmental grounds, might be for any number of reasons. Not only are there these technical reasons, there is of course also political reasons for changing regulations. The whole point of Brexit was that we would no longer need to follow EU rules, and we would be free to set our own rules. So there is a real political element in continued alignment with EU regulations. I can confirm, though, that the UK is about to conduct a major consultation on the product safety, on how it handles product safety regulations. This will be launched. We're expecting it quite soon. The CEA will certainly be consulting with all members on this hugely important aspect, and this will contribute to the policy discussions within UK government as to how it will handle future UK regulations in light of deviations, future deviations once EU regulations are amended. So we've had very understandably non-committal responses from the UK government to date. I've always asked the question in full expectation that I won't get a definitive answer. But now that these regulations are in the process of nearing finalisation, they're about to be published, we will very shortly have definitive dates. We need to know for certain what the situation will be as manufacturers, what the situation will be in the UK on the GB market. Sorry. So yeah, just to clarify, as soon as this consultation is launched, we will share that with members. But as of now, unfortunately, I can't give anything precise. I mentioned the GB market just to also then on this same post-Brexit related theme, just reiterate that Northern Ireland remains for the placing or for the selling of products, if you like, for the technical aspect of selling products. Northern Ireland remains in the EU single market, and therefore any products placed on the market in Northern Ireland from whatever that application date is, so probably January 2027, will need to comply with the machinery regulation. So regardless of what the UK decides for the GB market, the machinery regulation will be implemented in Northern Ireland as of the January or whatever date that is in 2027. Hopefully that that answers that question. Sorry, it's a bit rushed, but we're obviously very close to the end of the hour. And yeah, it looks like we have a similar question again from Cash. Will the supply of machinery regs in the UK be affected? So yeah, hopefully I've answered that one. I'll continue on that actually, because in just the last couple of weeks, the UK CEA policy team have held a number of so-called round tables where they asked UK stakeholders what their views were on the benefits that Brexit has brought, the challenges that it's brought, where things aren't working. How would industry or how would stakeholders like to see changes so that these challenges are resolved and we have a smoother access to market. I attended that, as did other CEA members. The chair of the CEA Technical Committee attended as well, and we gave a very thorough feedback as to where we saw the challenges and what we saw as the means to resolve those challenges. So they seem to be taken on board by the UK CEA policy team, and our responses will form part of this consultation that will be coming out in due course. So I think that's answered the question. Sorry, it was all very rushed, but I think we've just about managed it, because it is now exactly 2 o'clock. We're at the end of the schedule. I seem to have answered all the questions, and we've got through all the material. So with that, I'm going to propose that we end the session now. So thanks for your attendance. Please don't hesitate to get back to me. My email address is on that early slide in this pack. If you have any questions on the material that was covered or anything that wasn't covered, and you still have any questions, this is what I'm here for. This is my purpose in the CEA, is to answer members' questions, at least on technical aspect. So please submit them after this session if you like. The slides will be shared. This recording will be available on the website. So once again, thank you very much for your time, and we will now close this presentation. Thank you and goodbye.
Thank you.